who's filing a lawsuit against the healthcare law. He's holding a press conference this morning. It's just getting started.
This afternoon, and I'd like to first start out and introduce the two gentlemen standing beside me here. Wow, that's really loud. We have Mr. Rick Essenberg, who is the counsel of record for this lawsuit. Rick is president and founder of the Wisconsin Institute for Law and Liberty. He will be talking really about the filing details and the basic legal case of this lawsuit. And then I have Mr. Paul Clement, who has been retained to consult on future and potential appellate issues. And of course, Paul is a partner at the Bancroft Law Firm here in D.C. He was the 43rd Solicitor General of the United States under George W. Bush. And of course, how I became familiar with Paul was he was the attorney arguing against Obamacare in front of the Supreme Court, and I attended all four of those sessions. So certainly am very grateful that these two gentlemen have joined me here today. This, of course, is a lawsuit that I'm filing against Kathleen Archuleta and the Office of Personnel and Management to overturn their ruling that gives members of Congress and their staff special treatment under the health care law. Why am I doing this? There's really two basic reasons. The first is I think it's just a basic issue of fairness. I really do believe the American people expect, and they have every right to expect, that members of Congress, the political class here in Washington, should be fully subject to all of the rules, all of the laws that Congress imposes on the rest of America. And that is not the case with the health care law, and particularly with this Office of Personnel Management ruling. Now, you all have received a press kit, and we provided in there a pretty detailed timeline, a history of the legislative history of the passage of the health care law. But just to take you back to that moment in time, the public was pretty skeptical about this grand scheme, about, I'll call it the Patient Protection and Affordable Care Act. It is doing neither of those things. But because the public was skeptical, Democrat supporters of this law basically made a covenant with the American people. They put on a pretty good show. They wanted to show the American people that they were eager, they were more than willing to benefit from the health care law, but also be subject to all the rules, all the regulations of the health care law. They were eager, that is, until they really started thinking about what the true effect on themselves would be. And of course, that's when they went running to President Obama for special treatment, and they got it. Now, I realize there's been some dispute in terms of whether this is really special treatment. So let me describe exactly how egregious the special treatment is and exactly what it is. Now, it is true the members of Congress were singled out by the health care law to lose their employer-sponsored care. But let's face it, contrary to President Obama's repeated assurances, his broken promise that if you like your health care plan, you can keep it. By the way, that's been termed now the 2013 Lie of the Year by PolitiFact. We are now realizing that millions of Americans have lost their health care coverage, including members of Congress and their staff. Now, millions more, the millions that have already lost it primarily are people that are getting insurance through the individual market. The next wave of lost policies is going to be those individuals getting their health care coverages through their employers. And I think that's really the issue here, because those individuals currently are getting tax advantage health care benefits through their employer. When they lose their coverage, now they're going to have to obtain it through an exchange. Exactly what members of Congress and the staff are having to do. Here's the difference, and here's the special treatment. Only members of Congress and their staff, when they lose their employer-sponsored care, will have the ability to have their employers make a tax advantage contribution to the health care plan. That's the special treatment. That's completely unfair, completely unjust. And that's what I'm trying to overturn with this particular ruling, or this particular lawsuit. Now, if you take a careful look at that legislative history, you'll notice that the Senate, when this law was before them, had three opportunities to actually allow an employer contribution. When Senator Harry Reid first filed the law, there had been all kinds of committee activity And that allowance for a contribution was included in that committee work, but he chose not to include it in his law. And then Senator Grassley twice offered amendments that would have specifically allowed an employer contribution. The last time, on March 24th, 2010, that amendment was put up to a vote, and it was defeated by a vote of 43 to 56. So it wasn't like this is something that Congress didn't consider, that this was something they didn't understand. This was specifically debated and rejected. And so what we're talking about here is that this is the law of the land. If members of Congress, if this administration don't like the law of the land, they should come to Congress to change the law of the land. They should not change it by presidential decree or presidential fiat. And that's really brings me into the second part of the reason I'm bringing this lawsuit, is to uphold the rule of law. I think this lawsuit will hopefully provide a very long overdue check on presidential power, expanding presidential power, particularly with this administration. We are certainly seeing it, and I think we'll see it over the next 3 years. A real abuse of executive authority by this president. And so, that's one of the primary issues, one of the primary reasons I'm bringing this lawsuit. So we've certainly seen it as it affects the United States Senate with the National Labor Relations unconstitutional recess appointments. That was one instance where certainly as senators we were able to file an amicus brief. One of the reasons I'm filing this lawsuit is because, in general, members of Congress don't have or can't establish legal standing to bring a lawsuit. I truly believe this is one of those cases, and we'll certainly have Mr. Clement talk about that, in which I believe I do have standing, and as a result, I believe I have the obligation to make this point, to overturn this rule, to try and reestablish the check and balance, that very careful balance that our founders put into the Constitution to limit the size, the power, and the scope of government. With that, I'd like to turn it over to Mr. Rick Essenberg. He can talk about the legal issues of the case. Rick?
Thank you. The lawsuit was filed this morning in the Northern Division of the Eastern District of Wisconsin, where Senator Johnson lives. The Northern Division sits in Green Bay, and the case has been assigned to Judge William Griesbach. As Senator Johnson pointed out, when Congress passed the Affordable Care Act, it knew that some people, including those who had employer-provided coverage, would lose it. To build confidence, to, in simple terms, accept for themselves what they were about to mandate for millions of other Americans, Congress decided that the only coverage that would be made available to members and their staff was that which could be purchased on an ACA exchange. There is no doubt about that. Section 1312D3D of the Affordable Care Act provides that the only health plan that can be offered to members or their staff are those that may be purchased under an exchange created under the Affordable Care Act. For our purposes this afternoon, there are two types of exchanges. One is a small business exchange, and on those small business exchanges, a tax-free subsidy can be paid by an employer on behalf of individuals who are purchasing on that exchange. But the Affordable Care Act explicitly defines a small employer as one with fewer than 100 employees. And so the only type of exchange really pertinent here are the individual exchanges established under the ACA. And neither the ACA nor any other provision of the law permits those who are purchasing insurance under those individual exchanges to receive tax-free subsidies. Nor does the law covering the Federal Employee Health Benefit Program provide for payment of tax-free subsidies for policies purchased under these exchanges, none of which qualify for FEHB funds. So as a legal matter, Congress got what it wanted. Members and their staff are getting the same deal as millions of Americans who have lost their coverage as a result of the ACA and must now purchase insurance on the individual exchanges. And as Senator Johnson pointed out, this was not a mistake. Congress knew this would happen. Prior versions of the ACA did expressly state that members and their staff could receive tax-free subsidies to purchase health insurance. But that language was not included in the ACA as it was ultimately passed. After the act was adopted, an amendment was proposed which would have permitted the payment of these tax-free premiums, subsidies by the federal government, but as Senator Johnson pointed out, that was not passed. Unfortunately, what's happened is having chosen to make this display of solidarity with those who would lose their coverage, Congress now, turns out, doesn't really want to feel their pain. Now, the simplest way to avoid the inability to pay these premiums would be to change the law. But as Senator Johnson pointed out, Congress has not done this and does not appear to want to take a vote on the issue. And so what has happened, as has happened so frequently with the ACA, is the law as it has written is being ignored. OPM has promulgated a rule in which it has decreed that the federal government, an entity with almost 3 million civilian employees, is actually a small employer for purposes of participation in the small business exchanges, and that members of Congress and their staff, but only members of Congress and their staff, may purchase on the individual exchange, on the small business exchange rather, and receive these tax-free subsidies, even though no one else who works for someone other than a small employer would be able to do this. This is quite frankly unlawful. Unfortunately, it is one of many examples in which the Affordable Health Care Act has been unilaterally altered, deferred, exemptions granted, or there's been a simple refusal to enforce the laws as it has been written. It is not the most egregious example, perhaps, but it is one that Senator Johnson is able to do something about. So from our perspective, this case is not about whether or not members of Congress and their staff should be able to receive tax-free employer contributions to their health insurance. It's about the rule of law and whether that rule of law should be followed. And we're confident that if we're able to make our case in the United States District Court for the Eastern District of Wisconsin, that position will be upheld. With that, I'll turn things over to Mr. Clement.
Thank you, and I just wanted to pick up where Rick left off there, and as he indicated, when the Affordable Care Act was passed, it was an act of Congress that the President signed. It included a number of very specific deadlines, very specific formulas, and what has happened as the implementation deadlines have come to the fore is that the administration on multiple occasions has relaxed those deadlines, changed the rules, said this part of the law, that part of the law won't go into effect on the date that Congress specified. A lot of people in looking at those executive branch actions have said that those are contrary to the law that Congress passed, but they were doubtful that somebody would have standing to bring a challenge to those executive actions. This action by the executive here to essentially eliminate an aspect of the law that Congress thought was important, namely that members of Congress and their staffs would be subject to the same health care system with its limitations as the constituents. That provision through this OPM rule has likewise been relaxed. What we think makes this different, though, and what we think gives somebody, and Senator Johnson and his staff members in particular, standing to raise an objection, is that this doesn't just affect everybody in the country. This is not an abstract concern. This is a provision that specifically affects how Senator Johnson and his office get their health care. It affects how the senator classifies employees within his office for purposes of their eligibility. So unlike a classic challenge to a statute that is a generalized grievance that affects everyone, this is a challenge to the implementation of a statute that is specifically directed to the Senate, Congress, their offices and how they get health care. So we think that critically distinguishes cases that are out there that suggest that in many instances legislators do not have standing to raise objections in court. In particular, I think there are two things that really make this case very distinct. One is the fact that this directly impacts the Senate in his office and how he administers the office and how those individuals receive and pay for health care. So it's not a generalized grievance, it's a law that affects those offices specifically. The second thing, though, that I think distinguishes this from other circumstances is that oftentimes you have legislators bring court cases when they haven't been able to prevail in the halls of Congress. So the classic example is a senator who doesn't like the war in Vietnam or something and then brings a court action to challenge the legality of that action after having lost a vote to defund the war or something like that. This, in a sense, is the exact opposite. As both the senator and Rick have indicated, Congress specifically considered the question of whether or not members of Congress should get their health care in the same way as their constituents. They made a conscious decision in vote after vote, essentially to create parity with their constituencies. So if health care turned out to be a great boon, well, then all the boats would rise together. If it turned out to be a problem, then members of Congress and their staffs would suffer through the same problems and would experience those problems firsthand and perhaps would be best positioned then to address those problems. And in this sense, the OPM rule, and this is the heart of the challenge that's been filed today, really interferes with that congressional judgment. It stops what happened in the halls of Congress and effectively relaxes the impact of the decision that Congress made to make Congress and its staff members directly deal with the exact same health care situation as their constituents. And so that, too, I think really makes this a case where, unlike past efforts by legislatures to litigate in the courts, and unlike these other instances in which this administration has not implemented the law that Congress passed, this is a real ability in this case for the senator and his staff to raise this objection directly in court. So we do think, we feel confident that there's standing in this case, and we look forward to having the opportunity to litigate this, this issue in court. Thank you.
Now we're happy to open up to questions. Yes?
Over here. Now that you can't be on FEHBP, how do you and your staffer get health insurance? And if you were successful here, what do you think is the most fair way for this situation to be remedied? Would you want to return to FEHBP or?
Right. For my own part, I'll just tell you my own personal experience. My wife went on the DC exchange and stopped almost immediately because, first of all, she couldn't get through. When she finally did get through, just the amount of personal information she had to log on to the system, certainly she was fully aware of the lack of any kind of security on the website. She just didn't want to go any further. So I support her in that decision. We actually ended up going to a broker in Wisconsin and just purchased health care still in the private market. Members of my staff also experienced the same problems, in many cases almost panic, as they were running up against a deadline, unable to log into the system, unable to get confirmation that they actually had health care. But from that standpoint, each instance of my staff members, their experience with the health care law is somewhat different, and we'll certainly be working with them long term to make sure that they can secure good, affordable health care.
Can't you or members of your staff, can't lawmakers or members of their staffs refuse these subsidies? Can't they just go on the individual exchange and sign up there and not, go through the small business one and get the subsidies?
It's actually what I've elected to do. I think most members are trying to just follow the letter of the law as it's been written and as it's been regulated. So I have no criticism of any member of Congress not doing what I'm doing in terms of taking advantage of the employer contribution, but I've chosen not to do so.
When you talk about what most Americans are going through and how that relates to what Congress's situation, but most Americans are getting their health care through employer-covered health care policies. So we're really talking about a smaller group of Americans that you're trying to make. Can you talk about how big
Sure.
that group is of Americans really that's comparable to Congress's situation?
Sure. That group is going to grow, and I think it's going to grow dramatically. And you know, I bought health care for the people who work with me at my business for 31 years. The decision now that the health care law is in place, and quite honestly, once the exchange actually gets up and running more effectively, this is going to even put, you know, greater pressure on employers to make a pretty simple decision from a business standpoint. Because now with the health care law, the decision is, do I pay $15,000 per year for a family plan, which is up $2,500 per year rather than reduced by $2,500 per year, which is President Obama promised. Pay $15,000 per year and try and comply with more than 20,000 pages of law and rules and regulation, or do I pay the $2,000 or $3,000 penalty, and I'm not exposing my employees to financial risk, I'm making them eligible for subsidies through the exchange. So what I've been arguing for years is that there will be all kinds of employers. There will be millions of employees that are going to lose their employer-sponsored care because the incentives are there for employers to drop coverage and have their employees obtain coverage through the exchanges. And so we're going to have a lot of people, a lot of Americans, millions of them, losing their tax-advantaged health care coverage, get dumped in the exchange, have to secure coverage after tax. Now, we can talk about the tax treatment. I've always felt that was grossly unfair, that if you get employer-sponsored care, you get a tax benefit, and if you're on the individual market, you don't. From my standpoint, that would have been one of the things I would have been pushing had I been here as one of the reforms. If you want to subsidize people's health care, individuals, let them enjoy that exact same tax advantage. And it's quite honestly what I want to see as a Republican proposal here shortly after the first of the year.
My question is talking about Congress singling itself out, not relating to what your constituents are going through. But it seems to me by getting employer-sponsored care, you are actually getting similar care to what most of your constituents are, right?
Again, what's happened...
The argument is philosophically what's right or wrong, but when you say you want to mirror your constituents, employer-sponsored care is what most people get.
I'm talking about the experience of Americans, millions of them that are losing their health care. Some have lost individual policies, but people are already losing their employer-sponsored care. And the special treatment is, if you lose employer-sponsored care as an ordinary citizen, you lose your tax advantage, and you now have to purchase, you know, after-tax dollars. Members of Congress were the only class, and our staff, that when we have lost our employer-sponsored care because of Obamacare, you know, for different reasons, but because of Obamacare, we get a tax-advantaged employer-sponsored contribution. And that's just unfair. That's unjust. It needs to be corrected. Sir.
If Congress were to take on this issue instead of letting the Obama administration change things, what's the right outcome here? Get rid of the subsidy, get rid of the grassroots provision altogether? What outcome would you like to see?
Well, again, if the administration wants to change the law to put members of Congress back in a position where, like you know, this reporter was talking about, most Americans get employer-sponsored care, they should come to Congress and pass the law to do so. That would be certainly one remedy for this. But I do not believe the President has the authority to just willy-nilly change the law, as he has done with, for example, the employer mandate, which is pretty specific, says that it shall be implemented no later than December 31st, 2013. Well, he just changed the law by presidential decree. That's the point of this lawsuit. The President doesn't have the authority, and at some point in time, he needs to be challenged on that.
What does happen?
Well, I'd like to be successful in this suit because I do want, as Mr. Clement was pointing out, it's extremely important that members of Congress have the exact same experience as the other millions of Americans that are experiencing, to their detriment, the health care law. It's one of the ways it'll force action. You know, we have been receiving thousands of emails and letters, and they're heart-rending, of Americans who actually want to see this health care law succeed and are shocked by the increase of premiums, are shocked by the fact that President Obama's promise was utterly broken. And now they're seeing their premiums double, triple, their out-of-pocket maximums double and triple, their access to the doctors that have kept them alive taken away from them, to the treatments that kept them alive. So I think it's, in order to prompt action here in the halls of Congress, to start repairing that damage of this bill, to limit future damage, I think it's extremely important that members of Congress experience that exact same harsh reality, those exact same pains that their constituents are. And that's not going to happen right now because this president, because Democrats by and large went running to him for special treatment and relief, granted them that. And I just think that's wrong. Sir.
A legal question, and I'm not sure who's the best equipped to answer this, but why is the court filing in Wisconsin rather than in D.C., since the D.C. exchange is the one that's providing the care?
You know, we have, for many years in my home state of Wisconsin, we had a rule that if you wanted to sue the government, you had to go to where the government resides. You had to go to the Capitol in Madison. And we changed that recently in recognition of the fact, and this has been the rule in federal court for a long time, that taxpayers who are aggrieved by government action should be able to hail their government into court where they reside. We filed this lawsuit in the Eastern District of Wisconsin because that's where Senator Johnson lives. And it is in Wisconsin where his constituents, many of whom have lost their health care coverage and who are not able to get these tax-free premium subsidies from their employers, are feeling that pain. And we thought it was appropriate for us to file the lawsuit in Senator Johnson's home state.
Anything to add there?
No, I think so.
Sir.
Yeah, back on the employer-sponsored coverage. One thing that a lot of businesses are talking about doing, that are planning to drop coverage or drop in coverage, is provide their employees with extra compensation to go buy it on their own. Would you consider that as a solution to this issue to help your staff out? I mean, it wouldn't be tax-free subsidies, it'd be taxed, I presume, on the amount that they would get.
Sure.
But should Congress do that?
And on a case-by-case basis, that's exactly what I'll be considering, per staff member. I'm just naturally frugal. And so for the 3 years I've been here in Congress, every year I've underspent my budget by at least $500,000. Not only because I'm just frugal, but also because I knew this was coming. I mean, this is no surprise to me. I knew this was exactly going to be the result. What is bizarre is coming from the private sector, where when I hire somebody to work with me, I not only have to pay their salary, but I've got a budget for their pension plans and for their unemployment insurance and for their health care insurance. I understand those full costs. When you come here, it's a very bizarre system. A member of Congress's budget is only used to pay salary. Somebody else, the Secretary of the Senate, somebody else provides all these benefits. And so members of Congress don't really even know what they cost, which is, of course, part of the problem. But as a result, if this ruling were overturned, what we would force members of Congress to do now is start actually considering and understanding how expensive these benefits are. I've allowed myself the flexibility, retained enough budget to be able to make those types of adjustments so that I can help individuals work their way through that so they can, continue to afford to remain employed in my office. Sir.
You mentioned you're frugal and that you felt like this was an obligation that you wanted to do. How much does this cost? Who's paying for it? Particularly the retaining of Mr. Clement.
Right. Well, we had to go to Senate Ethics. I had basically two options: fund it personally, which I was willing to do, but then the Senate Ethics Committee did allow me, as a way to raise funds to do this, is to do it through my campaign committee. And so that's another way I can fund this. So I can do a combination or all of one, all of the other. I'm hoping to be able to, quite honestly, raise funds through my campaign committee. Now, an awful lot of members wouldn't do that. I mean, you've got campaign finance that limits contributions. When you're running for re-election, those can be some pretty precious dollars. So, but I think this is such an important issue that I think, I'm more than willing to either fund it personally or utilize those limited campaign funds. So that's how it's going to be funded. Ma'am.
Senator Donovan Slack.
Well, Donovan.
Hi. What do you say to critics? I think you have a fellow congressman, member of Congress from Wisconsin, James Sensenbrenner, who said that this is a political stunt and it will serve as a distraction away from what's really wrong with Obamacare. And he said then it will focus on a trivial issue. Mm-hmm. He's a Republican, Jim Sensenbrenner. What would you say to critics like him?
Well, first of all, I have a great deal of respect for Congressman Sensenbrenner, I always have. I'm disappointed. I'm a little puzzled by his reaction. This is an issue, really, that Republicans are, I believe, at least publicly, because they're on record voting for exactly this treatment. I think only 2 members of Congress, when this was brought before us during the whole funding of the government issue, end of September, early October, every Republican except for 2 in both chambers basically voted in support of exactly what I'm trying to do in this lawsuit. So I don't in any way, shape, or form believe this is trivial, that this is frivolous, that this is a stunt. This is, I think, a very important constitutional question. I think it's a very important issue that deserves a full airing, its day in court, and quite honestly, a very full public discussion and debate as well. So that's why I'm doing this. So I just respectfully disagree with the Congressman or anybody else who might have that hard feelings about it.
Senator, do you expect to see any more legislative proposals trying to address this issue? And if so, will you support them, or do you think this lawsuit is the best avenue to get
No, I was hoping for a legislative fix. I was a co-sponsor of the Vitter Amendment, which basically did this, but the Vitter Amendment, which I also appreciate the fact they were trying to add members of the administration, political appointees. Again, let's make sure the entire political class has the same experience, good or bad, that the American public do, okay? So I support the Vitter Amendment. The fact is that Senator Harry Reid refuses to allow even a vote on that. I certainly supported what the House did when they attached, basically the Vitter Amendment to one of those continuing resolutions. And again, I think every Republican voted for that in the House except for 2. And when Harry Reid voted or put that up to a vote to table that, every Republican senator voted against tabling that. We wanted to have a real vote on that continuing resolution with that provision. So one of the reasons I held off filing this is to see if there would be legislative action. Quite honestly, I was hoping maybe during the Budget Conference Committee negotiations. That might be something that we might have extracted as one of our wins in that, but that didn't happen as well. So, I mean, it doesn't look like this is going to move legislatively, so I think my only alternative at this point really is the lawsuit.
Kind of nerdy questions. You're asking that this rule be set aside. Part of this rule, I don't know if you're going after just part of it or the full rule, but part of the rule also clarifies that retired members of Congress and their staff would not have to go in the exchanges. Is that something you're also challenging? And then I have a second question.
It's certainly not an issue I've even really considered. I don't believe that's part of the lawsuit, is it?
It's not.
So we're talking about current members.
Okay, great. And then in some of the things you've said, and I think just a couple of items here in the lawsuit, you've mentioned or implied that members of Congress should have to get their health care through the exchanges. But looking at the actual wording in the Affordable Care Act, it says that the only coverage that can be offered by the federal government can be through the exchanges. Are you saying that they have to get their coverage through the exchange, or that they?
And of course, I'm
right.
I'm not getting it.
Okay.
But if the law really states the only thing the federal government can provide, or offer to is again, yeah. I'm not defending the law in any way, shape, or form. I want to fully repeal the law. I think it's
right.
causing all kinds of harm to all kinds of Americans. So I don't want to defend how poorly it was written, but it was written in a way, and I think the law is quite clear. This lawsuit is about enforcing that law and enforcing certainly a president that really feels utterly unrestrained by his obligation to faithfully execute those laws.
But members want to go in the private market. You think the law does not deal with that at all?
No,
right.
They're perfectly free to. I've chosen that option myself. Ma'am.
To follow up on that, if I understood you right, that means that effectively you've declined this subsidy, by going to the private market.
Correct.
I wondered if you knew how many lawmakers had done that. And my other question was, it's not clear to me how you're handling it with your staff. You said something about case by case.
Sure.
How is that working?
Well, first of all, I do not know how many other people have declined it. And again, I am not in any way, shape, or form critical of anybody that's just trying to follow the law, follow the rules as they're currently written, whether they agree with it or not. I mean, again, most Republicans utterly disagree. All Republicans utterly disagree with the health care law, but we're trying to follow it. So I was forced, and as part of the standing issues, I was forced to take action that I believe is not legal, is unlawful. So that's part of the issue. In terms of how my staff is handling it, they believe that they all did obtain coverage. And again, it's a wide spectrum in terms of what they did. Some of them decided not to take employer-sponsored care anymore and either got on a spousal coverage or, so we'll just, as we go back through salary reviews, we'll be talking to those individuals on an individual basis in terms of, well, what's it costing you? What kind of harm was done? Let's take a look at your overall pay package. So I don't have any blanket rule on that. It's going to be very, very flexible from that standpoint.
Some presumably then did take the employer-sponsored.
Oh, I imagine they all are. I'm imagining all of the people, all my staff members, I think most people here in Congress and staff did take the employer contribution. Again, I'm not being critical of that. I'm being critical of a president who knows no legal bounds and is doing things by presidential decree. Sure.
One more.
Are you losing your staff because of all of this?
No. No, and I know that's one of the canards, I would say, is that there's just going to be a huge brain drain here. We're going to lose all kinds of senior staff. I mean, I think that's up to members of Congress if somebody's disgruntled or, one of the first terms I learned when I came here is, again, totally outsider, never served in any kind of elective office whatsoever. But the first term I heard interviewing potential staff members was cashing out. It's not like this is a new phenomenon. So the fact of the matter is it's a constant issue with members of Congress and their staff in terms of how do you retain good people. And there are a lot of good people here. So that's just an issue people are going to have to deal on a case-by-case basis with individuals. I guess we have time for one more?
That was my last one.
Or not? Oh, okay.
One more.
Okay. Well, thank you all for coming. Really do appreciate it.
Is that going to get to the press packet? We still have some more.
I'm okay with an interesting weekend.
Again, I am happy. Understanding what